Hey everyone, this is Anna Gressel, and you're listening to the AI Drop, your briefing on how AI is reshaping the future of business law and industry. We bring you fresh drops each week so you never miss a beat. Welcome to the podcast. Welcome, everyone. Earlier this year, the Delaware Court of Chancery, one of the country's most influential business courts, worked through a $250 million earnout dispute in which a buyer's CEO had used ChatGPT to build a strategy for getting out of the payment. And the CEO's AI prompts ended up as evidence in the case, laying out the company's own strategy about what it had been trying to accomplish. Today, we're going to be asking what really happens to your company's legal advice and strategy once it passes through an AI tool and what to do about that. And to help us map this terrain around AI and privileged, I'm joined by someone who works at this intersection every day, and I'm super privileged to team up with him on these matters. Rob McCallum is one of my partners at Freshfields, and he's a tech litigator, and we just have a great time working together on these kinds of issues. Welcome, Rob.
Thanks, Anna. Great to be here.
Rob, so you may or may not know this, but I like to start off these podcasts with some lightning round questions.
I was not aware of that, but happy to participate. Let's go.
Yeah, surprise. Welcome to the podcast. So question one, coffee, tea, or something else to get you through your document reviews?
Coffee for sure, black, no sugar.
Love it. Same here. What is the last thing you actually asked AI to do for you? Because I know you use AI a ton in your work at the firm. And did it work well?
It did. About half an hour ago, I plugged in a couple of prompts to Copilot suggesting that I might be participating in a podcast in about half an hour, and I wanted some help to prepare for that. And the answer to the second part of your questions is yes, it was very helpful.
I bet it did not ask you what you drank during your doc reviews, though, did it?
It did not prepare me for the lightning round.
All right, well, still has some work to do to get a little sharper. Okay, if you weren't a litigator, what would you be doing, Rob?
I would love to be the lead singer of U2, but the job is unfortunately filled for now. I also can't sing, so that's a problem too.
Okay, and finally, would you let an AI note taker sit in on your dinner party debates, and why or why not?
Dinner party debates, I would be okay with a note taker sitting in on, depending on where the records of those conversations went. I'd be a little more hesitant using a note taker in some of our sensitive day-to-day work discussions.
That's fair. I actually think for me, dinner parties, no, because I like people being able to just freely express themselves without like social media or any of that. But now I'm fully dating myself in that response to that question. So, Rob, let's dig in a little bit on AI and privilege. Just start us off with some basics. How are AI and privilege questions actually showing up for companies? And has that changed over the past year?
So in terms of how are those questions showing up, those are coming up in my practice pretty much every day at the moment. Can employees use ChatGPT? Can lawyers use AI to analyze commercially sensitive documents? Should I be uploading privileged materials into an AI system? What if it's an enterprise system versus a public system? And if I upload privileged materials, am I at risk that these are going to somehow become part of the model that's powering the tool? So in terms of how those questions and conversations have been changing, I would say a year ago, maybe a little more than a year ago, the big question was, should I be using AI at all in the workplace? People were very concerned about risk of hallucinations and so forth, waiver of privilege. But I would say if you fast forward today, most companies have adopted some kind of an internal AI tool. And so the conversation has very much shifted from should we be using AI at all to how do we use AI safely and responsibly?
We'll talk in a moment about some of the emerging case law in AI and privilege, because I think it's important to give people a grounding in that. But before we even get into the cases, can you give some of the folks on the line, including a lot of our non-lawyer listeners, just a little bit of a primer or a refresher on what attorney-client privilege protects, what attorney work product protects?
Yeah, sure. So I would say in very general terms, attorney-client privilege protects confidential communications between a client and a lawyer that are made for the purpose of obtaining or providing legal advice. And then separate and apart from that, we have the concept of attorney work product, and that's a little different. It generally protects materials prepared by or for lawyers in anticipation of litigation. So in terms of what it protects and what it doesn't protect, attorney-client privilege generally protects the communications and not the underlying facts. And you can't just make facts privileged just by discussing them with a lawyer, for example. And along the same lines, work product doesn't necessarily protect every single document touched by a lawyer. The key question is really whether the material was prepared because of anticipated litigation. So confidentiality is a concept that's common to both of those types of protection, although work product protection information can sometimes survive disclosures that might otherwise destroy an attorney-client privilege communication. But as a general matter, once you lose confidentiality, there's a risk that you also lose the privilege or the work product protection that goes with that.
And tell us a little bit, like, where does Gen AI come into the equation?
So it comes into the equation, and I guess complicates the analysis as to what is protected by attorney-client privilege or what is protected as attorney work product, because the underlying technology is pretty complicated. So I mentioned earlier the importance of confidentiality to maintaining the privilege. And one question that just keeps coming up is whether the information that is put into an AI tool really is confidential. And so the answer to that question can depend on the particular tool you're using. Different tools can have different security profiles, for example. Some are public-facing systems, some are enterprise products with contractual confidentiality protections. Some retain user data, some don't. Some use inputs for model training, some don't. So it's really the underlying technology and the complexity there that makes the analysis more complicated than it's historically been.
I think that that's a perfect lead into the Hepner case, which, as many folks who are listeners will know, really set off a lot of discussion and chatter in the legal industry around AI and privilege. And in particular, that case found a waiver of privilege in that instance, but it's a very, very particular set of facts. So Rob, maybe you can tell us a little bit about Hepner and why it started appearing all over our LinkedIns. I'm sure that was true for you as it was for mine, and what to really make of the case.
Sure. No, the Hepner case certainly blew up my LinkedIn feed, as it did for many people. I think the reason it attracted a lot of attention is because it was one of the first judicial opinions in the US that addressed whether communications involving an AI tool can be privileged or protected as work product. So in that case, the defendant used a public version of ChatGPT to generate a set of memos to assess potential strategies in his case, and he later handed over those materials to his lawyers. Following his arrest, there was an argument over whether those memos could be treated as privileged or protected. And ultimately what the court did is it just walked through the basic requirements for attorney-client privilege and for attorney work product protection and found that the memos didn't meet those requirements, and so they had to be disclosed.
And other courts have come out different ways. Can we talk about what the facts were driving the court's analysis there and how that's differed from some of the facts at issue in other cases, including the nature of the AI tool?
Sure. So since Hepner, there's been a number of other cases dealing with similar issues. I think what you can glean from those cases is that they demonstrate just how fact-intensive the privilege questions are and will likely to continue to be. And so we're not necessarily seeing the courts disagree too much about the underlying legal principles. They're just evaluating different technologies and fact patterns, and in some cases reaching different conclusions based on those different fact patterns. So one example would be the Warner case, and that was actually decided the same day as the Hepner case. In that case, you had a self-represented litigant uploading case filings to a public version of ChatGPT, similar to in the Hepner case, and the self-represented litigant asked legal questions while preparing for litigation. Now, unlike in Hepner, court found that certain prompts and responses were protected from disclosure as attorney work product. And part of the reasoning for that decision was that the self-represented plaintiff in Warner was essentially functioning as her own attorney, and so she was entitled to work protection over those materials that were related to the legal strategy for the case.
So let's decode this a little bit for companies that are thinking about using AI tools, because we see, as you mentioned before, a true spectrum of AI tools that are being made available on the market. One of the core factors that I think Hepner really looked at is the ability of the tool to maintain the prompts and responses as kind of private, which is what we would typically expect, for example, in an enterprise-grade tool versus a publicly available tool where that may not be something that is afforded to the consumer under the tiers of their plan. And of course, there are different kinds of tiers of different plans. So we're not talking about any one tool here. But how important do you think that particular piece of the calculus is in light of what we were just talking about on confidentiality?
I think it's hugely important. And what we've seen is that the courts are willing to dig into individual terms and conditions and security profiles of different tools and look at that overarching confidentiality profile to come up with an answer to the question, was there reasonably an expectation of confidentiality here? So there's no defined set of relevant factors or questions, but some of the points the courts have been looking at is the tool public or enterprise based? Does the tool have contractual confidentiality commitments? Whether the AI provider receives and retains user information, and whether the prompts can be used for model training, and that's really just a couple of examples. I think the key takeaway is that not all tools are created equal, and just because something is an enterprise-grade solution doesn't necessarily mean that you can assume that the data will be kept confidential for all purposes. And so if you are a company considering onboarding a particular AI tool, I would encourage you to kick the tires on that and make sure you understand the security profile of the tool and the terms of use in particular.
Yeah, I think that's a great point. This comes up a lot, but companies that are ingesting AI prompts and responses, and they're providing this kind of intermediate layer in between the vendor and the consumer. And there, we've actually seen circumstances through diligence where the vendors have the ability to look at the prompts and responses. They may not be holding them in a confidential way because we have this whole company in between. So this really, I think, just goes to the critical importance of diligence for companies to do on their vendors using AI and think about the privilege implications and whether those tools are essentially fit for purpose in the use by legal teams. So I would definitely say double click on that if you're in-house and you are thinking about how to protect privilege for the company. There's also a different angle on this, Rob, and I'd be curious for your views. What is the difference in the privilege analysis when people start potentially using tools to actually self-serve legal advice? What does it mean when there may or may not be a lawyer in the loop? And does that matter?
I think it does matter because one of the takeaways from the Hepner case is that your chatbot is not a lawyer and can't dispense legal advice. Doesn't mean that you can't use AI to assist with the provision of legal advice, but if you're a non-lawyer and you are consulting with an AI tool for privilege to attach, there really does need to be a lawyer involved. And so I think that the key takeaway there is that your chatbot is not your lawyer, and unless you can satisfy those basic requirements of the attorney-client privilege, which is a communication with an attorney, it's unlikely that the output is going to be privileged.
And I want to just talk about one other set of tools that comes up all the time in conversation today, and those are AI note takers. And there are a wide variety, again, of different kinds of note-taking apps. They work in a bunch of different ways. What are some of the main questions you think companies should be asking as they evaluate note takers and when to use them, whether to use them? What are the privilege? And maybe I'd even add in litigation risks around that.
So we are getting a lot of questions about this, and the functionality of these tools is pretty amazing. Very powerful tools that can save a lot of time generating notes and summaries of meetings and perhaps even interviews. There's a couple of things I would encourage folks to think about before enabling this kind of transcription functionality in their organization. And you mentioned litigation risks, so I'll take that with a broad brush. First, bear in mind that you might be introducing another technology provider into potentially privileged discussions. So for the reasons we discussed earlier, you should make sure that you're familiar with the security profile and the terms and conditions of any tool that you're using. Another issue to bear in mind is that you're creating new records that might later become discoverable. So for example, if you use a tool to create a meeting summary, then the tool might first need to create a detailed transcript so that it can then generate the summary. So you should be aware of which new records you are creating and where those records are stored. And depending on your organization's IT infrastructure, those records might be stored in a different location or even a different jurisdiction to the rest of your records. And a third issue that I think you should bear in mind is risks around accuracy. And you alluded to this, that some of these tools are sufficiently advanced that they can even identify speakers in the room and so forth. But they can make mistakes as well. They could misidentify speakers, for example. They might not catch every word that is spoken. And one aspect that's common to many AI tools is that they are not always good at handling nuance. So something that a speaker intended as a joke, for example, might get recorded in a transcript as a statement of fact.
Frankly, I see it on our AI-generated transcripts of the podcast, right? And, we can flip my name and the person that I'm talking to. But we also hear stories about this at the executive level of names being switched or someone jumping in and then comments attributed to them after that. So it's critically important to think not only about how they work in practice, but as you mentioned, what is happening with them afterwards and whether they're being verified or if there's an obligation to verify them before putting them into something like a company record where that can actually be preserved for a longer period of time. And even the preservation obligations attributable to recordings are the thorny area we see a lot of companies working through these days. It's, I think, particularly important for regulated industries or folks with preservation orders, for example. So it's a very interesting, complex area right now. And I think we're thinking about it a lot. Rob, this is also, you mentioned this, and I just want to pull on this thread a little bit, but we've been in the weeds on some of the international components of this with some of our colleagues who we practice with worldwide. What are some of the big differences that jump out to you when you think about either privilege waiver risks or even the question of whether outputs might be privileged under different jurisdictions and how they think about privilege issues?
It's a good question. I think at a very high level, there are going to be distinctions between how these issues play out in common law countries versus civil law jurisdictions. So a number of common law jurisdictions apply a version of attorney-client privilege or attorney work product protection that has very, very similar features, whether that's in England or Australia and other parts of the common law world. That said, there are going to be nuances in how the courts in different countries interpret aspects of the privilege and the protection and how they interpret those issues in practice, including, for example, who they determine to be the scope of the client group. That is one common distinction between the United States and England. In civil law jurisdictions, there is typically a reduced obligation to disclose documents, and partly as a result of that, the doctrine of privilege that applies in those jurisdictions is also not as broad as it might be, for example, in the United States. And so in the context of the digital age and the sharing of information across borders, a corporation that operates in multiple jurisdictions might need to take account of the various, sometimes competing jurisdictions and levels of protection available for documents in different jurisdictions.
Just going back to Hepner one more time, one of the things I thought was quite interesting about that opinion and generally about privilege doctrine and operationalizing it in practice is the importance of labeling or containing information. What is the role of a label in the world of privilege?
In the world of privilege, the label actually doesn't make something privileged or lead to a waiver or anything of the sort. Whether or not a communication attracts privilege is purely a matter of whether or not the communication satisfied the basic requirements of the attorney-client privilege that we referred to earlier. That said, it does fulfill a helpful role in that it can serve as a flag, particularly to others within the organization, that this is a sensitive communication that might need to be treated differently to other communications, and that dissemination of that privileged communication should also be limited and not broadly disseminated within the organization so as to preserve privilege. For those companies that find themselves in litigation and have to go through the discovery process, for example, those labels can also serve a useful function in that they flag to outside counsel who are reviewing those documents for privilege in advance of production, that maybe that's something that outside counsel needs to take a closer look at and make their own privilege assessment as to whether the document should be produced or whether it's privileged and can be withheld.
Yeah, and I think it also is increasingly serving a data governance function. And what I mean by that is we see organizations when we come in on the governance side, on the AI governance side, trying to make sure that their AI governance policies are paired up nicely and synced up with their data governance and data classification. So if they have something that is material non-public information or something that is restricted and confidential or something that's a trade secret or privileged, that it is treated accordingly. And so the importance of making sure that your data governance is in order has become, I think, critical in the age of AI when agents can move documents around, even potentially across borders. And so we're seeing a lot of effort by companies to try to shore up their data governance and some of those corresponding practices to make sure that then they can operationalize their AI policies or their privilege policies based on the right fundamentals.
That makes a lot of sense, and I would expect that those questions are going to get tougher and tougher as the rise of agentic AI continues, as it has been.
For sure. I want to just go back to something you said earlier, which is about verification. You are really active in teaching our associates how to use AI. I love all the work that you're doing. And frankly, the excitement that exists on your team, it's really fun to watch. I sit on the same floor as Rob for folks who don't have a sense of how we're organized within our organization. And so I get to see a lot of the juniors that work with him day in and day out. How do you think about balancing that excitement with the need to teach juniors how to verify AI? Are they in tension with each other? Is that just something that junior associates are beginning to intuit as part of general good practice for working with AI tools?
I think there is a bit of a tension there, but there's no doubt in my mind that we all need to be as AI enabled as we can be in order to give our clients the best service, and that moving on, I think that the best lawyers in the future will be the ones who are able to leverage the AI tools in order to improve their work product, their output, their efficiency, and so forth. But it's also critical that they go through that verification process. And there is a little bit of a tension there that although you absolutely absolutely need to check every single AI-generated output for accuracy, certainly before it's submitted to a court or to any other outside audience or relied upon. You can't have the verification process mean that you've ultimately obtained no efficiencies from using the tool. If it takes you just as long to actually verify the output as it would have taken you to produce it the old-fashioned way, then you haven't really achieved much. So the tension or the balance to be struck is, how do you get the most out of the tools and then do enough verification that you've satisfied your professional obligations and produced the best work product possible, but you're comfortable that you've manually verified everything that needs to be manually verified.
Okay, Rob. So then break it down for me. When I see your excited associates in the hall and they're bubbling with eagerness to tell me about how they're using AI tools, how does that actually fit together when you think about the life cycle of a matter, and where are you finding you're getting the most impact from your use of AI?
Well, first of all, that's great to hear that they're bubbling with excitement and enthusiasm, because they don't necessarily always tell me that. So I'm glad you've noticed that. The way I like to think about this is through the lens of the life cycle of a dispute. And we've sat down and given a lot of thought to mapping out everything that we do as litigators as part of our day-to-day jobs, and starting with pre-litigation advice through the filing of pleadings, amended pleadings, motions to dismiss, moving into the discovery process, what that looks like from a document discovery process, what that involves in terms of depositions, moving into expert discovery, trial, appeals, and then of course you've got settlement and mediation that sometimes cut across different stages of the life cycle. And we try to think about what are the tasks that we as lawyers do as part of each stage of the life cycle, and which of those are good candidates for automation or augmentation. And at this stage, not every task that we do is a suitable candidate for augmentation. And so we try to isolate those where we think we can really add value for our clients. And I host a weekly innovation meeting where we challenge each other to come up with the best prompts for the most repeatable tasks and where those fit within the litigation life cycle. And we've had some really great results from that. It's encouraged a lot of cross-pollination within the firm, folks talking to each other about best practices in prompting and where they can share knowledge and expertise across the firm. It's been a real pleasure to be part of that process.
Think about all of our clients that we advise together. I know you and I work on a number of matters. I think we see some really small legal departments. I think we see some very large legal departments within our clients who are focused on these issues. If you're thinking across that wide spectrum, what are a few practical steps that you'd encourage companies to take, whether it's on privilege specifically or managing their litigation risk profile around their use of AI? What would you want them to leave the conversation with today?
Sure. Well, I think the key word is governance, and that can mean different things to large organizations versus smaller organizations. I would encourage folks to think about whether they have a good understanding of which tools are available to their employees for work purposes. And that should be an immediate focus. If you don't have a good handle on that, then you do need to get that understanding. And then for each of those tools, I would encourage folks to make sure they understand the security profile of the tool so that you can then get a handle on whether it can be used without a risk to confidentiality and a waiver of privilege for all of the reasons that we were talking about earlier. I would say education and training is really important. You need to have some rules of the road in place. So that could, for example, be a policy on the responsible use of AI, and that could be quite simple for a small organization or a little more involved for a larger organization. And it might cover, for example, which tools are approved for work purposes, guidance on what kind of sensitive information can and cannot be uploaded to the tool, and guidance on what to do and who to contact if an employee makes a mistake, for example, and uploads sensitive information to a public tool.
Yeah, I think the reactive piece is really key. As AI use scales, unfortunately, we are seeing this happen in practice, and making sure that you have clear communication protocols, clear escalation protocols that you can figure out and easily contain the scope of that. That can be really critical, particularly if you're operating on a short time scale. It's a trade secret, for example. It's highly sensitive data, and you have to actually get in the weeds and figure out what happened. So I completely agree with that. And then the other thing I would just mention is it's always interesting to think about what are just good technical measures to take down your risk, because sometimes we do see people doing things that they didn't realize were wrong or entering things into tools that they thought were approved and weren't. Rob, thank you so much for joining us today. I'm sure there's a lot for us to continue discussing, and it's just been a real pleasure to have you on.
Been a pleasure to be here. Thanks so much for having me.
That's today's drop. Thanks for listening. If you'd like to hear more of the AI Drop, hit subscribe and join us each week for fresh insights on what's shaping the future of AI. This podcast is for informational purposes only, and it does not constitute legal advice or establish an attorney-client relationship. It may be considered attorney advertising, so prior results do not guarantee a similar outcome. The views expressed here are those of the speakers and do not necessarily reflect the views of their firms, organizations, or clients. For more information, please visit freshfields.com.